Kilmar Garcia was deported to El Salvador and now is held there in one of the most secure and frankly scary prisons. The government of the United States stated that they had a right to deport him, yet the courts disagreed and ordered that Trump's administration facilitates the return of this man back to the United States. But let's talk about this. Could the government deport this man, and under what circumstances the government may deport someone from the United States if they received something called withholding of removal? Let's dive into it. My name is Alena Shautsova. I'm an immigration attorney from New York. I've been practicing immigration law in the United States for 17 years. And here I'm going to explain to you what's happening in this case. The details of this case I got from the media, of course, because I'm not one of the attorneys working on this case. But let's dive into it. We know that Mr. Garcia is a citizen of El Salvador. He's 29 years old. We know that at some point the United States immigration judge ordered Mr. Garcia removed, but also ordered to withhold his removal. As such, Mr. Garcia was granted something called withholding of removal. If, for example, you would have his A number, alien identification number, and would punch it into EOIR immigration court system, you would see that he was ordered removed. Withholding of removal is a very interesting status that is given to somebody who's more likely than not to be threatened in his home country, to be harmed there based on 5 protected grounds: religion, nationality, race, membership in a particular social group, or political opinion. Withholding of removal is a status that allows one reside in the United States and have a legal work permit, but they cannot become a green card holder and they cannot travel overseas. Like pretty much any immigration status in the United States, it may be taken away under certain circumstances, and this is very important. In fact, our laws state that withholding of removal may be taken away either by USCIS, if it was USCIS immigration authorities that gave you the status, or by an immigration judge. In our case, in the case of Mr. Garcia, it seems that it was an immigration judge who granted Mr. Garcia withholding of removal. Now, under the law, these are the circumstances when withholding of removal, after being granted, may be taken away. The procedure is called termination of withholding of removal, and can be granted, for example, if there is a fundamental change in person's country conditions, so that they're no longer in danger if they're sent back. Number 2, fraud during the application. So it means that the status should have been granted to begin with, or discovery that the person committed certain crimes that would disqualify them from withholding or removal, or the person in a nutshell is a danger to the United States. But how the government should go about that? Can they just grab the person and deport them? No. They have to give them a notice, and in the case of a person who received withholding or removal by the immigration judge granted that relief to them, the government has to reopen those proceedings, and then the judge has to revoke the status. And it is my understanding that this is exactly what has not been done in this particular case. So the government, it seems, skipped that step and simply removed Mr. Garcia to El Salvador. And I think this is the biggest issue here, is the violation of his due process rights. It may very well be that if the government followed the procedures, they would have prevailed, because it seems that Mr. Garcia had at least charges related to domestic violence, and perhaps there is some other criminal record that we are not aware of. But the point is that the law had to be followed, and it seems it has not been.